This is where the legal history of the Troubles was written. The fate of thousands of defendants was weighed up within these walls. Society and the justice system have moved on, but one legal relic remains. Trials linked to terrorism can still be heard without a jury. But the clock is running on the legislation that underpins that. And with the devolution of policing and justice no nearer, it will be up to the Northern Ireland office to decide whether to renew it or to let it lapse.
Arguably, in 1973, when diplock courts were first brought in, there was a serious crisis facing society. But certainly that's not the case now.
I think that a jury trial, a jury system, particularly for terrorist-type offences, is simply impractical because of the threat that would be there to the lives of jurors.
Everyone is entitled to be tried by their peers.
The right to a trial by jury goes back to the Middle Ages. For centuries, it's been seen as a central pillar of the justice system. So why were jury trials ever taken away? Non-jury courts in Northern Ireland were a direct result of the Troubles. As the courts faced a growing workload of terrorism-related trials, a royal commission, chaired by Lord Diplock, was set up in 1973.
It was felt in some quarters that there was partisan jurors. There was also a real threat of jurors being threatened. And they were threatened, and they were threatened to lose their lives at the time. So it was very important that justice had to be done and seen to be done.
As part of the normalisation process, the government announced an end to diplock courts.
Northern Ireland's now moved forward enough to enable a return to a presumption for jury trial in all cases, even those that would currently be heard before a diplock court.
But that didn't mean an end to trials without juries. Under the diplock system, if you were charged with a serious offence, you were automatically listed for trial in front of a judge, meaning the decision on your innocence or guilt would be taken here. That decision was only taken by a jury sitting here if the Attorney General ruled that the case had nothing to do with terrorism. But in 2007, that was reversed. Now a defendant is automatically tried in front of a jury, unless the Director of Public Prosecutions decides the case is connected to terrorism. Then it was turned over to a judge. So non-jury trials are now meant to be the exception rather than the rule. In the 80s, on average, there were more than 300 diplock trials a year. Since July 2007, there have been 38 non-jury cases, but that's still one every 2.5 weeks. So while they're not as common, they are routine. And that's partly due to the persistence of dissident paramilitaries. The recent murders may well be a key factor in persuading the government to keep non-jury courts.
All of us would aspire to a situation in which a jury system would be available for all criminal sort of charges and on all criminal cases. But I think we've got to live in the real world. We've got to live in practicalities, and particularly when you're dealing with some of the dissident terrorists that have been out there, they seem to see virtually all of society as some sort of collaborators with the British state and almost anybody's legitimate target. The idea that in circumstances of that nature they would not target jurors, I think, is something which is just not plausible.
But in actual fact, the evidence is pretty thin. And there's been a lot of work done on imagining how you could deal with any cases of juror intimidation. For example, you could have jurors coming from a different town. You could have jurors leaving the courthouse by a different method. All these are issues that have been tried, when there has been evidence of juror intimidation in ordinary cases, and they've been quite successful. If you have non-jury courts, then the public is not involved in the criminal justice system and can wash its hands and say, well, it's nothing to do with us. That's the principle of the jury trial, that members of the public are involved in making decisions over people.
Non-jury courts are clearly still a divisive issue. We approached a number of organisations directly involved in the justice system, and although some of them are on record as supporting keeping non-jury courts, interestingly, None of them wanted to appear in this film.
We've got to take all the circumstances into account when we're thinking about someone's freedom, because at the end of the day, you could be removing someone's freedom for a long, long time. So I think it's important that we try and get the balance right.
Reform of the justice system has changed the way some courts look, but the wider plan was that by now, local politicians would be deciding the future of non-jury courts. But the devolution of justice has only crept forward, meaning the decision remains with the Secretary of State, a jury of one.